And I thought that I should start this first panel, before I turn it over to our panelists, by summarizing just for a minute what popular constitutionalism is, because that phrase may be unfamiliar to many of you. Popular constitutionalism has been called by many scholars the most important development in constitutional theory in the last 20 years. Other scholars have said that it's nothing more than the latest intellectual fad. I leave it to you to decide which of these two is accurate. So what is popular constitutionalism? Broadly speaking, it's a collection of theories that examines the significance of constitutional interpretations, constitutional arguments, and constitutional rhetoric outside the courts. As constitutional law, as it's taught in law schools, is almost exclusively focused on the development of constitutional doctrine in the federal courts, and especially by the Supreme Court. But the Constitution has a rich life outside the courts that scholars have only recently begun to take note of. In a variety of ways, the American people have been talking about and debating the meaning of the Constitution since the founding. These debates come up in social movements, like the Tea Party movement, or the gun rights movement, or the women's rights movement, that employ constitutional rhetoric in advancing their positions. These debates happen sometimes in Congress, with some members of Congress urging passage of the Affordable Care Act in order to protect a right to affordable health care, and others arguing that Congress lacks power to mandate health insurance coverage. And these debates over the meaning of the Constitution happen in the White House and on Facebook, in which people weigh in. I don't know whether your Facebook page was as filled as mine was with reactions to the birth control decision and debate about whether it would violate religious rights to require insurance coverage for birth control or whether it's necessary to protect women's rights. So constitutional argument and rhetoric, it turns out, is ubiquitous in American life. So popular constitutional scholarship looks at this fact, and it comes in two chief flavors: a descriptive flavor and a normative flavor. The descriptive kind of popular constitutionalist scholarship examines how these popular understandings of the Constitution affect the understood meaning of the Constitution. So these scholars have examined how social movements and public debates about the Constitution outside the court have influenced the meaning of the Constitution both inside and outside the court. For instance, in 1872, when the Supreme Court decided Bradwell versus Illinois, it was obvious to every member of the court that the Equal Protection Clause does not guarantee equality based on sex, and that Myra Bradwell could be denied the opportunity to practice in the Bar of Illinois because she was a woman. But by 1996, when the court decided the VMI case, all members of the court agreed that the Constitution prohibits sex discrimination. What had happened in the intervening years? The text of the Equal Protection Clause hadn't changed, but the women's suffrage movement and the women's equality movement had launched sustained public efforts that succeeded in changing the American conception of equality. And this changed conception of equality had filtered its way up to the Supreme Court when it decided the VMI case. The same is true for gun rights. In 1939, it was obvious to a unanimous Supreme Court that the Second Amendment does not guarantee an individual right to own guns for personal use. But by 2008, when the court decided the Heller case, it was equally clear to a majority of the court that the Second Amendment does guarantee such a right. So what had happened? Well, the NRA had launched a sustained public campaign to convince the public and to defend a right to own guns as a constitutional right. And it had largely succeeded in convincing the American people that gun possession is a constitutional moment. So as these scholars have shown, social movements and public debates and conflict outside the courts are a prime reason for change in the understood meaning of the Constitution inside the courts. That is, popular constitutionalism, these popular debates about the Constitution in public and social movements, is not a sidelight to constitutional doctrine, but is actually central to explaining its development. And for the descriptive varieties of popular constitutionalism, they don't necessarily take a position on whether this is a good or a bad thing. They're simply explaining the relationship between the Constitution outside the courts and the Constitution inside the court. Now, popular constitutional scholarship also comes in a normative flavor, in which scholars assert that the people generally should have greater control over the meaning of the Constitution. That is, that the courts are not the exclusive or the ultimate interpreters of the Constitution. And in these writings, scholars challenge the notion of judicial supremacy, sometimes judicial review. Far too often, popular constitutionalists of this flavor believe judges serve as the sole expositors of constitutional meaning, and that people equate the adjudicated Constitution with the actual Constitution. That is, we've come to understand and conceive of the Constitution in terms of judicial pronouncements. So, in organizing this conference, it seemed to me that the set of issues that are addressed by popular constitutional scholars, many of whom are here today to talk about it, are especially relevant in this election cycle, in which the meaning of the Constitution is being hotly debated by the candidates and by movements every day. So, perhaps I should have started, by the way, by welcoming you. Welcome to our conference before I launched into my long spiel about the meaning of popular constitution. So anyway, welcome to our conference. I'm glad everybody could come. So let me introduce now our first panel, which will address the significance of constitutional narratives. Professor William Forbath has argued that progressives have ceded the ground to conservatives to construct a vital constitutional narrative around national values. Professor Zietlow counters that actually progressives employ their own constitutional rhetoric and narratives, as can be seen in the congressional debates over the Affordable Care Act. And Professor Solum argues, and I know that I'm caricaturing his view, that narratives don't ultimately matter in the development of normative constitutional theory. Or to caricature it even more, he will argue narrative schmerative. So let me introduce I'll introduce each one of them independently now. So Professor William Forbath, our first panelist, is the Lloyd M. Benson Chair in Law and the Associate Dean for Research at the University of Texas School of Law, where he teaches constitutional law and legal theory. He's among the nation's leading legal and constitutional historians and is the author of Law and the Shaping of the American Labor Movement, as well as dozens of articles, book chapters, and essays on legal and constitutional history and theory. His scholarly works appear in the Yale Law Journal, the Harvard Law Review, Stanford Law Review, and many other leading journals. So let me now turn it over to Professor Forbath.
Thank you. It's a pleasure to be here, a pleasure to hear the senator evoke the tradition that I want to talk about today. So my basic idea is a simple one, and it's that those of us, like the senator, like myself, like some gathered here, no doubt, progressives are forgetting how to think and talk about the constitutional dimensions of economic life. Work and opportunity, material security and insecurity, poverty and dependency, unions, workplace democracy. For generations of reformers, the constitutional importance of those subjects was self-evident. Laissez-faire, unchecked corporate power, the deprivations and inequalities that they breed weren't just bad policy, they were constitutional infirmities. Today, though, with the exception of employment discrimination, such concerns largely have vanished from progressives' constitutional landscape. And that has to change because, as Jarrett suggested and as the senator illustrated, constitutionalism is the language that Americans most often use to talk about the basic rights of citizens, the basic duties and responsibilities of government. Constitutionalism supplies the higher law against which existing social arrangements and economic ones and the laws that uphold those arrangements can be judged so wrong, right, as to warrant extraordinary engagement and even disruption in the name of supplanting them. What's more, As Jarrett said, the popular constitutionalism of social movements has been the seedbed of congressionals and court constitutionalism. And at the same time, right, the highbrow oppositional constitutionalisms of academics and policy mavens, right, on the margins of power, often inspired by popular constitutionalism, one stripe or another. This kind of highbrow constitutionalism has proved a dress rehearsal for the arguments of lawmakers and courts when the political moment is right. As Jarrett illustrated in respect of women's equality, but one could make the same argument about most of our most important economic statutes, the kind of super statutes of our economic history, from antitrust, right, to Social Security, the right to join a union and strike, the anti-discrimination norm. All of them followed the path I just sketched. They were rights claimed in the streets or the meeting halls, right? Rights that academics defended and courts generally spurned, but rights that Congress and state legislatures eventually took up, and then courts treated them as fundamental for a long season, in some contexts, like antitrust, although not presently, and for a short season in other contexts, like union rights, right? The air today is thick with Constitution talk. That's not surprising. It's always been thick with Constitution talk in moments of grave economic crisis. What's different about today is that almost all of it, both highbrow and popular, is on the right. The Tea Party and its legislative and judicial allies have brought the old laissez-faire constitutional case against public social provision from the right-wing blogosphere and the libertarian legal intelligentsia, of whom some of the most distinguished lights are here, right, into electoral and congressional debate and into the opinions of federal judges. So right-wingers are bent on reviving the anti-redistributive or laissez-faire case in constitutional law and politics. In my opinion, their theory of interpretation is bunk, but they're correct in their practical understanding of constitutional politics. Movements for change need an account of past constitutional contests and commitments that add up to a vision of the nation that, in Jack Balkin's words, the Constitution promises to promote and redeem. And their Constitution, right, fits that bill. Right? It gives an account of an America fundamentally committed to rugged individualism, private property, godliness, right, and the safety of rights, property rights from state interference. Much progressive fire is focused on right-wing originalism as a method of interpretation. But too often these arguments from those of us on the left have focused more on method than substance, right? The main reason I think conservatives dominate our public constitutional debates is not so much that they have a killer theory of interpretation. It's chiefly that they have a bolder and clearer narrative about the nation the Constitution promises to redeem. So you see, I'm setting up a big target for Professor Solum. I am offering you an account of our constitutionalism that does treat narrative and vision as an important element in the way law develops, right? And our politics evolve. I also want to suggest, right, that of course the other reason that the right-wing narrative and vision of constitutionalism prevails isn't simply the power of narrative, but another element that I think probably Professor Solum will think is equally irrelevant, but that's political economy. That's the organized clout of those who promote, right, a right-wing vision of our constitutional development. So I want to say a word about two things going forward. A a little bit of, and I'm going to put my watch down so I don't tax your time too long. How much more time do I have?
Say, 10 minutes.
10 minutes, okay. So in 10 minutes, I want to talk about two more things. I want to talk about reviving, rediscovering, and reinventing the narrative portion of this progressive tradition in constitutional life, and also just a moment about constitutional political economy, where again, I think progressives the right outstrips the left, right? Thinking hard about the interplay between political economy, the organization, the way law plays on the field of power in social and economic relations, the way law shapes it, and the way in turn, right, interest groups, organized groups shape the law, right? And what the Constitution says about that set of interactions as well, right? Okay, so a narrative, a few thoughts about the interplay of one's constitutional commitments on the one hand and the kinds of political economic reforms and organizational reforms one envisions on the other. And let me finally say, just as a matter of amateur sociological observation, that there's a gap between progressives' most common response to the laissez-faire constitutional arguments and what I think are ordinary Americans' views, right? I think progressives have come to say the Constitution just doesn't speak to the rights and wrongs of economic life. It leaves that to the give and take of ordinary politics. That was the court's resolution of the New Deal crisis, right, in the courts, that we, the courts, will no longer stand in the way of economic reform in Congress, right? And so, as a matter of legal strategy, it may be well for progressives to argue just that. To those who say the Constitution condemns Obamacare, it may be well in court to say, no, the Constitution actually no longer, right, safeguards a conception of economic liberty which would condemn Obamacare. Right? It may be as a contingent matter for now that that's the right argument. But that wasn't all that, right, the foes of laissez-faire said at the time that laissez-faire was toppled as an economic outlook, as a constitutional outlook. They said Congress not only has the power to regulate the economy, to provide social provision and social insurance and social security and protect labor rights, it actually has the duty to do so. So that for a century, the battle against laissez-faire constitutionalism from the left side of the aisle, in the polity and in Congress, was about affirmative duties on the part of government. Ones that weren't to be taken up by the courts, but by Congress and lawmakers. And ones that entailed various kinds of deep reforms in the distribution of wealth and in the rights and obligations of employers and employees, and so on, right? And I don't think Americans today believe the Constitution is silent in regard to economic power. I actually think they expect their Constitution and lawmaking under it to shape the play of economic power in our society, whatever their politics. I think this is true on the left and the right. They expect lawmakers and judges to attend to the Constitution's promises of equality and of liberty in the way they make, say, competition policy, education policy, jobs creation policy. Now, had we whirled enough in time, if you were my students and I could keep you here for an hour, right, I could tell you in needlepoint detail about what I'll call this distributive tradition, right, over against the anti-redistributive tradition on the right. My claim is that the progressive constitutional vision has been a distributive one, has said that the Constitution does speak to the distribution of goods and power in our society, right? And along with history, I could enter Larry's domain and give you several philosophical reasons why what philosophers call our reflective understanding of constitutional democracy demands a measure of social democracy so that all Americans enjoy access to basic goods like education and livelihoods. But let me give you the gist of it. Okay, let me give you the gist of it. The gist is simple, and you'll see that it echoes some of the things that Senator Whitehead was saying. Gross economic inequality produces gross political inequality. You can't have a Republican form of government, and certainly not a constitutional democracy, in the context of gross economic inequality. And that's so for three basic reasons. First, such gross inequality produces an oligarchy or aristocracy in which the wealthy rule. In Senator Whitehead's terms, in which corporate wealth rules. Second, insofar as it produces deprivation and a lack of basic social goods at the bottom, gross inequality destroys the material independence and security that democratic citizens must have to think and act on their own behalf, and to participate on at least roughly equal terms in the polity and larger society, right? And finally, third, access to such basic goods isn't simply a matter of providing a material basis for people's citizenship, right? It's also a matter of individual dignity and standing in one's own eyes and in the eyes of the community. So that's, right, a plain-spoken philosophical case for why, right, again, to use the simple formula I used a moment ago, constitutional democracy in this tradition amongst progressives historically has been seen to entail a measure of what's often called social democracy. All right, now I'm going to change key. I have another 5 minutes? Okay. Okay, you won't regret it. It'll be fast, and instead of descriptive or sort of softly normative, this is diagnostic. What have been, if we look at the landscape over the past election cycle, in the polities, both, and I'm going to emphasize state now more than federal, where has the energy and the real heat, what anthropologists sometimes call hot politics in which people are really mobilized and engaged, right? We know where it's been on the right, right? It's been in the Tea Party, it's been in the primary debates, and it's been aimed at Obamacare and other measures, at least in terms of social provision and economic, like the things I'm talking about. That's where it's been. Where has it been on the left, right? It's been around labor rights. It's been in states like Ohio, Wisconsin, Indiana. It's been around the stripping of collective bargaining rights for public employees. Why is that so? I want to suggest it's so for two equally important reasons. Oh, I'm sorry. It's been so for two equally important reasons. Right? One is that labor rights also are part of what I've called a distributive tradition in constitutional culture. Right? In addition to access to basic goods, there's a long-standing view that, right, severe domination, dependency, the tyranny of the boss in the workplace, right, the inability of an individual worker to bargain for a decent wage or decent working conditions, all these things are fundamental rights. For a surprisingly long time, even in the bad old days, the courts recognized this. They didn't give it the kind of safeguards it might deserve, but they recognized the basic idea that the bedrock constitutional values of freedom of association, economic liberty, when the courts recognized it, all these had consequences for workers' labor rights. And when the legislators and governors in those Midwestern states I mentioned said about taking away those rights, right, there was a striking upswell of popular support. The idea that these were basic rights was still vibrant in places where unions were still strong. And hundreds of thousands of people took to the streets, got in the buses that the unions had paid for, and voted swiftly to repeal, right, the law in Ohio that had hollowed out collective bargaining rights for public employees. Right? Now, is this because working Americans think labor rights are the most important kinds of affirmative duties, right, that government has to honor and protect those rights, are the most important basic rights of citizens among the many that I've sketched in the economic realm? No. I wouldn't, even as an old labor lawyer, make that kind of claim. I'd rather say it's because of all the rights, right, and aspirations, the economic needs that Americans see as partly government's responsibility. Safeguarding those were the only ones that had some organized clout behind them. There were buses to take people to the Capitol. There was a circuitry, right, of union activists to bring them to sort of educate their anxieties and aspirations and bring them to the political arena in some fashion, right? Which is the simple point that we on the left could learn from public choice theory and other tools of right-wing constitutional political economy, that the polity doesn't listen to individuals. The polity attends to organizations. That what political scientists called secondary associations, right, are integral, not only to the exercise of constitutional rights, but to the exercise of political influence. And so, in that regard, we can see in the way in which people were able to rally around jeopardized labor rights, right, a lesson in another infirmity that we on the progressive side need to overcome, right? Namely to reimagine and rebuild, right, the laws that support various kinds of secondary associations that gather up aggregate the interests and votes, right, of poor and working people. Right? This is a slow motion constitutional crisis from the point of view of progressives. The extraordinary deterioration of the statutory framework that was meant to safeguard union rights in the private sector. Right? Mid-century, 40% of the private sector was organized. Today, less than 10%. Many reasons explain that, but a central one is the ramshackle, ruined state of the statutory framework that was meant to safeguard those rights. It is no coincidence, therefore, that public employee unions represent 40% of the workforce in the public sector, and private employee unions represent less than 10. They're governed by different bodies of law. I'm not here to commend to you that civil service laws should become the norm in our whole labor market. Far from it. I'm here to say that part of the constitutional project, for those of us who think about the Constitution outside the courts, right, is to reinvent the kinds of associations that enable working people, ordinary people, to make their sway felt in the workplace and in the bridges between economic and political life. And that, I think, right, is what this distributive vision of our constitutional tradition is all about. So progressives should be arguing about these kinds of problems as though our constitutional democracy depended on it, because from our point of view, it does. Thank you.
Thank you, Professor Forbath. We'll now hear from Professor Rebecca Zietlow, who is the Charles W. Fornoff Professor of Law and Values at the University of Toledo School of Law, where she teaches constitutional law. Her scholarship has addressed welfare reform, due process, and congressional enforcement of civil rights. She's written several pieces on slavery and the 13th Amendment, as well as articles on popular constitutionalism, including a recent piece on the Tea Party movement, and a piece on popular constitutionalism and the Affordable Care Act. So, Professor Zietlow.
Thank you. Thanks so much, Jared. It's great to be here. It's a very great subject that I'm really interested in, and wonderful company. Pleased to be here. As Jared mentioned, I've been writing about popular constitutionalism, actually on both sides. I only really realized this yesterday, but I just recently wrote an article on the Tea Party movement's constitutionalism, and in the talk I'm about to give, which is about the Affordable Care Act, the progressive side. So it was really about a battle between two visions of the Constitution, the congressional debate over the Affordable Care Act, and what I'm going to say, what I'm arguing today is that the Affordable Care Act is an example of progressive popular constitutionalism, and that it's a battle which, at least in the political realm, the progressives won when Congress enacted the Affordable Care Act. And that that we need to remember that there actually was a progressive constitutionalism narrative behind the Affordable Care Act that led to the Affordable Care Act during this time when it's being debated both outside the courts and inside the courts. So this long-term progressive campaign for major health care reform and for protecting the right to health care arguably began a century ago in 1912, when then presidential candidate Teddy Roosevelt put the right to health care as a platform, a plank in his platform. My work is about, in general, about what I call rights of belonging, those rights that promote an inclusive vision of who belongs to the national community and facilitate equal membership in that community. Now, constitutional scholars tend to view courts as guardians of those rights, protecting the interests of discrete and insular minorities. However, in our country, the progressive tradition, including our progressive constitutional tradition, as Willie was just talking about, has played out primarily on the streets, not in rulings by politically insulated courts. Political movements demand change, and legislatures respond to their demands by enacting legislation to enforce constitutional values like equality and freedom. Indeed, progressive constitutional change rarely, if ever, occurs without political activism. As former Attorney General Archibald Cox observed in 1965, Brown versus Board of Education, the paradigm of courts protecting rights was not truly law until Congress enacted the 1964 Civil Rights Act. Other scholars, including folks on this panel in this room, have linked constitutional change to political activism, and today I will briefly review some historical examples and apply my theory to one of the current constitutional debates, that over the Affordable Care Act. My choice may seem surprising to some. To the extent that healthcare reform has been linked to popular constitutionalism, it has primarily been the opposition to that act that has been the most vocal. The Tea Party activists attacked the act as an unconstitutional infringement on states' rights and individual liberty. And here, Tea Party activists have seized the rhetoric of rights. Often left out of this debate is the fact that the Health Care Reform Act itself did not come from a vacuum. As I said, it was the result of years of activism on behalf of affordable health care. Many supporters of the reform argued that health care was a fundamental right, and leading members of Congress who supported the act agreed. Indeed, the act protects one of the most important economic rights that Congress has ever recognized, the right to health care. Yet these days, supporters of health care reform seem limited to arguing that Congress had the power to enact the statute under the Commerce and Spending Clauses, this dry legalistic language that does not invoke the concept of rights. The progressive vision of fundamental human rights behind the act is eclipsed by these dry legal arguments. And unfortunately, the reframing of the issue could endanger these rights. Reviving the vision of fundamental rights, which was the basis for healthcare reform, is important not only to ensure that the act is sustained in the courts, but more importantly, to cement that right to healthcare in our constitutional consciousness. So for the remainder of the talk, I'm going to give us a short discussion of popular constitutionalism, democratic constitutionalism, and economic rights, a short history, examples of Congress acting to protect rights of belonging, which includes other examples of Congress relying on economic powers to enforce fundamental rights, including the National Labor Relations Act and the 1964 Civil Rights Act. Then I'll discuss the feasibility of the Affordable Care Act as protecting rights of belonging. And finally, I'll talk about the advantages of thinking about the Affordable Care Act in that way. As Professor Goldstein has described to us, popular constitutionalism occurs when people take to the streets and make constitutionally based political arguments, often through political movements, often behalf of rights that people see as constitutional rights. And sometimes elected officials respond to the popular constitutionalism and through the process of democratic constitutionalism enact measures consistent with the constitutional vision of these activists. In the area of economic rights, it's particularly favorable for this pattern of popular and democratic constitutionalism, in part because the court has stated over and over again that that there are no rights directly in the Constitution enforceable by courts, no economic rights. And also because the court defers to the political process in the economic realm. Throughout our history, then, Congress has relied on the court's deference and legislated to identify and protect economic rights. However, success has proven ephemeral for programs that were not adequately embraced as rights and treated instead as mere economic legislation by the court and our constitutional culture. Rather than arguing to courts, activists seeking to expand rights of belonging are most effective when they engage the popular understanding, and speaking the language of rights is the most effective way to do so. Now, historic examples of this phenomenon include the National Labor Relations Act of 1935, which created a federal right to organize into unions, bargain collectively, and strike. And of course, the NLRA grew out of years of labor activism, arguing that the right to organize and engage in collective bargaining is a fundamental right. Sometimes these arguments were made in constitutional terms, the argument being that the right was protected by the First Amendment, freedom of association, and the 13th Amendment protections against involuntary servitude. Members of Congress invoked labor's theories in debates over the act, arguing that the right to organize is a fundamental right, but they also invoked a more conservative narrative that the right to organize was necessary to avert strikes that impeded interstate commerce. Here, members of Congress were speaking to the court, which had struck down other New Deal measures and seemed likely to do the same with the NLRA. Eventually, arguably in part responding to labor activism, the court upheld the NLRA based on the more conservative commerce-based narrative. Since then, the court has repeatedly narrowed the rights, as Professor Forbath was telling us, protected by the NLRA, arguably gutting its effectiveness. Professor Jim Pope has argued that if Congress had based its power more expressly on the 13th Amendment and the right to strike was portrayed as a fundamental right protected by that amendment, the court might have been more deferential to the act, maintaining stronger legal protections for unions and their members. Another example of popular constitutionalism and democratic constitutionalism protecting an economic right is the Civil Rights Act of 1964, which created a federal right to freedom from race discrimination in employment, education, and privately owned places of public accommodation. The 1964 Civil Rights Act responded to years of civil rights activists arguing that freedom from race discrimination was a fundamental human right. Congress based its power to enact the statute on the 14th Amendment, invoking the Reconstruction era, and made it clear that freedom from race discrimination is guaranteed, or they believed is guaranteed by the Reconstruction amendments. But members of Congress also relied on the commerce power. Again, Congress was speaking to the court. In 1883, in the civil rights cases, the court had held that 14th Amendment enforcement power was limited to state action. And of course, the 64 Civil Rights Act was directed primarily at private action. Few members of Congress were sanguine enough to rely on the court to overturn this precedent and uphold the 1964 Act. Sure enough, the court upheld the act as an exercise of the commerce power and did not mention the 14th Amendment. While the 1964 Act endures, the state action limitation on the 14th Amendment enforcement power continues to hamper congressional efforts to protect rights of belonging, as seen in the court's decision striking down the civil rights remedy of the Violence Against Women Act in U.S. versus Morrison. Reva Siegel and Robert Post have argued that if the court had been forced to consider the 1964 Civil Rights Act as an act enforcing the 14th Amendment, it would have upheld the act and done away with the state action doctrine. Again, an opportunity arguably was lost when human rights legislation was framed as an exercise of economic power. These examples show that to the extent that economic powers have come to eclipse the fundamental rights protected by those statutes, the rights have been weakened. Now, the 2010 Patient Protection and Affordable Care Act, is it really an act protecting rights of belonging? I think there's a good argument that it is. It expands health care coverage and affordability to millions of Americans. In addition, the act prohibits discrimination based on race, sex, national origin, disability, or age by health programs administered by the federal government or receiving federal financial assistance. In an amicus brief in the 11th Circuit case of Virginia versus Sebelius, the National Women's Law Center argued that the ACA is a civil rights law because it addresses the discrimination that women experience in the healthcare market. By extending Medicaid to cover more low-income people, the Act expands coverage to women and racial minorities who are more likely to be poor, and thus the ACA takes an important step in ensuring equality of access to health care. But I'm most interested in the extent to which the ACA recognizes a fundamental right to health care. There is a good reason to believe that this is the case. As I said, it responded to years of activists demanding that health care is a fundamental right, based on a tradition of activism going back for 100 years. And the argument for expanding access to health care has been repeated and sustained throughout the 20th century. The right to health care is recognized as a universal human right under international law. And domestically, a number of federal measures create precedents for the ACA. The government has taken on the responsibility for medical care for the elderly, the disabled, and the poor in Medicare and Medicaid Acts. These measures represent a federal commitment to provide health care for those who are most likely to need assistance. They reflect the view that health care is important enough to justify a huge commitment of finances and other resources, implicitly recognizing the right to health care for at least part of the U.S. population. The fundamental right to health care is also implicit in the 1986 Emergency Medical Treatment and Active Labor Act, which requires doctors to treat patients who require emergency medical care. This act, which passed without controversy in 1986, reflects the consensus that in the United States one should not die on the streets due to one's inability to pay for emergency treatment. But this mandate from EMTALA also arguably was one of the principal reasons why, which necessitated the controversial individual mandate in the Affordable Care Act. During congressional debates over the ACA, members of Congress repeatedly invoked the tradition of activism. Many supporters of the act affirmed that health care is a right, not a privilege, and that the ACA would protect that right. Members of Congress have also invoked the Commerce Clause, pointing out the economic impact of the lack of access to affordable health care. Members of the American public during this debate, polls show that they were most concerned about their own health care, but they were also concerned about its availability to others. During debates over the ACA, polls consistently showed that over 60% of the American public favored a federal guarantee of health care for all Americans. The argument that the ACA protects a fundamental right to health care has its weaknesses. Most importantly, of course, it does not create a universal right to health care. There are significant gaps and loopholes in the complicated apparatus that this ACA established. This is due in part to the fact that the movement for health care was considerably less robust and widespread than the movement supporting the right to organize and the Civil Rights Act. During the 1930s, millions of workers participated in strikes to support the right to organize. During the early 1960s, Americans were captivated by television images of Martin Luther King and his supporters and by the congressional debates over the act. On the other hand, during the past decade, though a consensus had developed that our healthcare system is broken, there was a relative lack of consensus of how to fix it. Another weakness is that healthcare is arguably more like a mere economic right than is the right to organize and to be free of race discrimination. Nonetheless, there are significant advantages to remembering the argument that the ACA protects a fundamental right to health care. While the court usually defers to Congress in the economic realm, courts tend to value human rights over economic rights. But more importantly, when courts and the people embrace rights-based argument, these rights tend to be more robust and enduring. Once a right is widely considered to be fundamental within the popular understanding, it's hard to take it away. There's now a national consensus that racial discrimination is illegal, both illegal and immoral. When considered, while controversial when adopted, Social Security and Medicare are now considered to be the third whale of politics. The right to organize is more complicated and more politically vulnerable, as recent events in Ohio, Wisconsin, and Indiana reflect. With regard to health care, already, however, lawmakers find it difficult to take away the protection against the denial of coverage for pre-existing condition, the most popular provision of the ACA, which necessitates the unpopular individual mandate. Perhaps this is why House Budget Committee Chairman Paul Ryan and the Republican House wants to do away with Medicare altogether, replacing it with ineffective block grants, challenging the premise of the ACA that health care is a fundamental right. Ryan's proposal may require health care reform advocates to go to the mat and take a stand on behalf of the fundamental right to health care. Again, this would require popular constitutionalism and action on behalf of a fundamental right. As everybody knows, lower courts have issued conflicting rulings on the constitutionality of the ACA. The Supreme Court is going to rule on it sometime this year. And in the courts, lawyers defending the ACA focus on whether it falls within the commerce or spending powers. A more important argument is the argument that the ACA protects a fundamental human right. Even if the court overturns the ACA, Congress will need to adopt other measures to protect that right. Obviously, this will only happen if there continues to be a consensus that health care is a fundamental human right. And the ultimate future of the ACA in particular, and the right to health care in general, depends not on the courts, but on the boots on the ground and the effectiveness of political advocacy. When it comes to rights of belonging, litigation is simply no substitute for political action. Thank you.
Thank you, Professor Zietlow. Our final panelist on this first panel is Professor Lawrence Solum, who is
Solum.
Solum. Oh, I'm sorry. Professor Lawrence Solum, who is an internationally recognized legal theorist who works in constitutional theory, procedure, and the philosophy of law. He's a professor at the Georgetown Law Center, where he is currently teaching legal philosophy. He's also the editor of Legal Theory Blog, an influential weblog that focuses on developments in contemporary normative and positive legal theory. He's the author of numerous widely cited works on constitutional and interpretive theory, as well as legal philosophy. Professor Solum.
Thanks so much, Jared. It's a real pleasure to be here. When I received Jared's invitation, I could not resist being at a conference that includes so many distinguished scholars whose work I admire so much. So what I'm going to be talking about in general is the idea of narrative in constitutional theory. And the remarks that I had prepared were somewhat dense and academic in nature. And so I've done one of these things that one occasionally does. I've thrown away my prepared remarks, and I'm going to make a slightly different set of remarks that more directly address the issues that have been raised in the conference so far. But let me begin with narrative. We tell stories about the Constitution, many different kinds of stories. Some of these stories are grand constitutional narratives. They're stories about the fundamental meaning of the Constitution, the values that it's founded on, the way it changes over time. There are stories, for example, about a constitution in exile and attempts to bring it back. There are stories about constitutional redemption and a constitution that began in darkness with the protection of slavery that was partially redeemed by the 14th Amendment and then betrayed by the end of Reconstruction, with developments after that partially redeeming the promise of our Constitution. And there are less grand narratives about the Constitution, stories that shape the way we understand our constitutional tradition. Some of these stories are powerful but mythical. So many of you may be familiar with the story of Marbury versus Madison that posits that Chief Justice Marshall used sort of a very unique opportunity to make a power grab and institute a new thing, judicial review. Well, this is a story that is absolutely false, but that plays a very powerful role in our understanding of the Constitution. Some of you may have heard the story of the switch in time that saved 9, the reverse in votes during the New Deal era that resulted in New Deal legislation being upheld by the Supreme Court. And that's a complicated story, but the simple version of it, that President Roosevelt's court-packing plan directly led to a switch in the key vote, we know is false. So narratives are important, and narratives are powerful, but narratives are not always true. The constitutional narrative is playing a very, very important role in the current election. I think we're going to hear more about that later. And it certainly is the fact that constitutional narratives have a very powerful effect on the way that we think about the Constitution and the way that the Constitution is interpreted. That's because the Constitution is in part the Constitution in action, the Constitution as it is interpreted by the Supreme Court, is in part a reflection of constitutional politics. And narratives, stories, propaganda, rhetoric affect politics. No one should doubt that. One more point before I go to the heart of my remarks, and that's this. We want to be careful about what we mean when we say Constitution and constitutionalism, right? In one sense, an important sense, in my opinion, the Constitution of the United States is a document. It had an original text, and it has a series of amendments. And that Constitution, I think, plays a central and important role in our polity. But there is a wider sense of constitutionalism that's also important. In a wider sense, our Constitution is the basic set of institutions that shape our political structure. In that sense, things that are not in the written document are of fundamental importance. For example, our Constitution makes no mention of political parties, but the party system is an important and foundational element of the political system in the United States. The Constitution makes no mention of Social Security, but the Social Security Act is so fundamental to American economic life that we could say it's of foundational or constitutional importance. The remarks I'm going to make are about the Constitution in the first of these two senses. I'm going to be talking about the written Constitution and the role that it plays, and how narratives shape and sometimes distort our understanding of the Constitution. Narratives are powerful, but narratives are problematic. Narratives are inherently selective. Telling a story about our constitutional history is not a matter of recounting all of the facts that are salient to our constitutional development. That story would be very, very long indeed, and it wouldn't shed light on our constitutional practice. Narratives are selective. Narratives, therefore, are to some extent inherently simplistic. They simplify. They take a massive detail and they abstract features from that detail. They extract features from that detail that seem of salience, illuminating, somehow telling us something important about how constitutional law has evolved, where it comes from, what values it reflects. But because narratives are selective and simplistic, narratives can be sophistic. That is, narratives can distort rather than illuminate. So I'm going to talk about a narrative about originalism. And Professor Forbath, in his remarks today, echoed a quote that I have in my outline. And Professor Forbath said the following in print, very similar to the things he said today. The reason conservatives dominate our constitutional debate is not so much that they have a killer theory of interpretation that sells well with the public. It is chiefly that they have a bolder and clearer constitutional philosophy and narrative about what kind of nation the Constitution promises to promote and redeem. Originalists' theory of constitutional interpretation is bunk, but originalists are correct in their practical understanding of constitutional politics. Much of what lends originalism its public appeal is the narrative of a traditional nation that it promises to restore. An America dedicated to personal responsibility, limited government, private property, and godliness. This narrative has aroused citizens, lawmakers, and judges to act boldly on its behalf. So I'm going to suggest another story about originalism, a different story. The story that I'm going to provide is a story about originalism as a theory and not originalism as a political practice, although the theory that I'm going to elaborate has a role to play in constitutional politics. So what is originalism? Well, there's a long and interesting story about originalism as an idea. The term originalism was coined by an academic, Paul Brest, then a professor, later dean of Stanford Law School, and he coined this term to name a view that he opposed. And his naming caught on. And it caught on especially with the people that he was trying to criticize. That is, in a very ironic sense, Paul Brest invented the view that he had hoped to demolish. Early on, originalism was about the intentions of the framers. That view was severely criticized. Originalism, for a moment, was about the original understandings of the ratifiers, and that theory, too, was criticized. And as a result of that intense criticism, a lot of theoretical activity occurred. And the current version of originalism, the theoretical version, the academic version, the version that theorists of constitutional interpretation debate about, focuses on the original public meaning of the text. And this version of originalism is still evolving. Originalism is a dynamic research program that is, in my opinion, still in its early stages. But there are two things that originalists agree on. One thing that they agree on is that the linguistic meaning of the text, the communicative content of the text, the meaning of the words and phrases of the Constitution is combined by syntax and grammar, was fixed at the time each provision of the Constitution was enacted. And now when I say the meaning is fixed, the linguistic meaning is fixed, I do not mean that the applications are fixed. Obviously, applications could not be fixed in that way. I mean that the meaning is fixed. And let me just give one example of the way in which linguistic meaning is fixed. The original Constitution uses the phrase domestic violence. That phrase today has a new meaning. We think of domestic violence as violence within the family, child abuse, elder abuse, spousal abuse. When the original Constitution said that the United States government would have to assist the states in cases of domestic violence, they did not mean that Congress was obligated to enact a program of grants that would assist states in the prevention of spousal abuse, child abuse, and elder abuse. They were concerned about riots and insurrections. The meaning was fixed. And then the second idea is that the meaning of the text, the words of the Constitution, should have constraining force. That the participants in our constitutional system, the courts, the president, the Congress, officials at other levels, citizens are in some sense bound by this document, constrained by the document. Now, different originalists have different ideas about how constraining it could be, under what circumstances the Constitution might have to give way to other concerns. Some originalists would say never, ever, ever. Other originalists would say in the case of a national emergency, provisions of the Constitution might be required to give way. But all originalists agree that it should have constraining force. So now what does this commit us to? This idea that the meaning, the linguistic meaning, not the applications of the Constitution, was fixed, that it establishes a structure or framework, and that we are constrained by that framework. And I'd like to talk about some of the issues that have been discussed already this morning. So one of those issues was the jury. And many of you in the audience, I'm sure, are familiar with the fact that the Supreme Court has recently made a series of decisions that increase the power of judges to take cases away from juries. The Twombly case and Iqbal case mentioned in our keynote lecture this morning are examples of that. What does the text of the Constitution say? The Sixth Amendment reads, "In suits at common law where the value in controversy shall exceed $20, the right of trial by jury shall be preserved, and no fact tried by a jury shall otherwise be re-examined in any court of the United States than according to the rules of the common law." Well, this is an interesting provision of the Constitution because it seems to have originalism built into it. It says that the right to trial by jury at common law shall be preserved. And if we were to interpret that provision in an originalist manner, I think it would have profound implications for the right to jury trial. It would mean, I think, that a substantial amount of the Supreme Court's pleading jurisprudence is unconstitutional. It would mean, some have argued, that our summary judgment practice, another device for taking cases away from the jury, is unconstitutional. And it would mean that other jury control devices, the device of remittitor that sort of, this is perhaps contentious, blackmails plaintiffs into giving up part of their verdict, one from a jury, would be unconstitutional. Originalism would not restrict the right to trial by jury. What about corporate speech? Well, the whole issue of corporate speech, I think, is complicated, but let me give one example of the way in which an originalist reading of the Constitution might lead to surprising conclusions about corporate speech. The United States Supreme Court has tried to somehow, it's always struck me that this is somewhat implausible, has tried to somehow say that the freedom of speech, as it's applied to the states, is part of the meaning of the due process clause of the Constitution. And of course, there's been a lot of criticism of that move. Now, many people believe that the 14th Amendment to the Constitution does have something to do with the Bill of Rights, and in fact, there were many, many references in the debates that led up to the passage of the 14th Amendment by the Reconstruction Congress of such a relationship, but they had to do with a part of the Constitution that we don't study much in the law schools because the Supreme Court has essentially written it out of the Constitution, the Privileges or Immunities Clause of the Constitution. And the Privileges or Immunities Clause has an interesting feature. It extends rights only to citizens, not to persons, and uncontroversially, it would not extend rights to corporations. So an originalist reading of the Constitution would not necessarily lead to the enhancement of corporate rights. We talked earlier about Bradwell versus Illinois, and I am going to apologize to Jared for picking on him, but Jared's characterization of Bradwell was that all of the justices in that case had one view of the Equal Protection Clause, and that view has changed because we have changing ideas about equality. Bradwell versus Illinois did not mention the Equal Protection Clause. Bradwell versus Illinois was a decision about the Privileges or Immunities Clause of the Constitution, and it was not the case that all the justices unproblematically thought that the Privileges or Immunities Clause did not extend economic rights to women. In fact, Chief Justice Samuel Chase dissented in Bradwell versus Illinois. So it's not so clear that originalism means a constitutional vision that's associated with conservative political causes, and I think we might hear some more about that later today. But our Constitution does not establish all the rights that progressives might hope for, although our constitutionalism might do more. Our Constitution does not establish labor rights. There's no mention of labor rights in our Constitution. And contrast that to Article 23 of the South African Constitution, which reads as follows: labor relations. Everyone has the right to fair labor practices. Every worker has the right to form and join a trade union, to participate in the activities and programs of a trade union, and to strike. Now, that is a constitution that guarantees rights to labor, but our Constitution has no similar provision. The National Labor Relations Act, a profoundly important statute, might be part of our constitutionalism, although it is clearly contested now in a way that it was not early in its history. But our written Constitution does not guarantee labor rights. Do we have a right to health care? Well, perhaps we may someday. A right to health care may become part of our constitutionalism someday. But there is no right to health care in our Constitution. It contains no provision that even arguably is a textual guarantee of a right to health care. So if you accept originalism, there is some that is sweet and some that's bitter. Originalists, as theorists, as people who believe in a written constitution with fixed meaning that should constrain our constitutional practice, have to accept conclusions about the law that they like and those that they wish they could change. Some of that change can take place through the political process, and other change might take place through constitutional amendment. But originalists believe that constitutional change should not take place through amending constructions and judicial fiat. Thank you.
Thank you, Professor Solum. I think I'm going to let each of the panelists have a minute to respond to each other if they want, and then I'm going to open it up for questions, and maybe we can take a total of, let's say, 12 or so minutes for all of that, and then we'll take a break, and then have the next panel. And as a moderator, I think I can have the privilege of responding first. I just want to respond to your point about Bradwell. And this is just to say that I think what I said is accurate, that is, no justice thought that it violated equal protection to bar women from practicing law. I wasn't trying to suggest that originalism requires the result in Bradwell. I think it's possible to interpret the meaning of equal protection as an originalist matter to support the VMI decision or the court's current equality jurisprudence, especially if one follows the sort of originalism that Jack Balkin advocates, in which, at least the way I might characterize it here, one would describe the original meaning of equality at a high level of generality. That is, the Equal Protection Clause guarantees that the government must treat like people alike. VMI is consistent with that. Once the court then has to apply that to a real case, are women really alike, similar to men, so that they have to be treated equally? That's that version of originalism in which one understands the original text at a broad level of generality, I think is perfectly consistent with our current sex equality jurisprudence. My point, though, was entirely different. My point, though, was that the change in the court's understanding from Bradwell to VMI is not due to some change in the court's interpretation of the text, but it's change in its understanding of the world informed by social movements outside of the court. That was my only point, which isn't inconsistent with originalism or any other theory of interpretation. Well, so with that said, I just want to turn it over to my other panelists to see if they have any responses, and then I'll open it up to questions.
So I'll be very terse. Actually, the Constitution, of course, does have a provision that speaks directly to labor, and that, of course, is the 13th Amendment, right? And indeed, I am, a fan of the kind of broad-gauged originalism that Jack Balkin, our keynote speaker, promotes, and others too. It seems to me, right, but that one can do a lot of good work with that kind of originalism. Returning to Larry's point for one more lick at it, indeed, the framers of the 14th Amendment, whose texts folks like you and me love to pore over, right, actually said in respect of the promise of equal citizenship, it includes a promise that, and here I'm paraphrasing, I didn't realize we'd be poring over text quite like this, or I'd bring it with me. But one of the principal Senate framers said it speaks to the inequalities of the working man and the capitalist, said it speaks to preventing a caste of the money. Language like Senator Whitehead sort of brought up to date. Whitehouse, forgive me. Senator Whitehouse's language brought up to the mid-19th century. So one can, from the public meaning of both the 13th and the 14th Amendment, right, work up a great deal of the constitutional underpinnings of labor rights, and those who framed it did so, and so did Brandeis a few generations later. Brandeis said, in respect of a statutory construction that upheld repressing strikes, this, right, were we to read it the way the majority reads it, it would be involuntary servitude. So it is true that I think inadvertently many of our most important provisions in the Constitution envision the kinds of construction that perhaps, for reasons that aren't to me very theoretically clear, you're condemning. I'm not sure one can have it both ways. And then just a sort of delicious development in the emergence of originalism, right? As long as we're telling stories about originalism, it is striking to me that some of the most prominent originalists today on the right have lit on the idea that, unbeknownst to its framers, the 14th Amendment does vouchsafe women's equality. It's true that even at the time there were those who thought it did, but now it's said that without doubt the anti-caste principle of the 14th Amendment commands women's equality from a certain originalist point of view. So it is certainly true that the kind of text we've been given can undergird progressive and conservative results and meanings. And none of it can be understood without narratives, right? Originalists need narratives no less than do other schools of interpretation. Rebecca.
Well, just briefly, I think, to the extent that I maybe have a dispute with Larry, although I'm still not really sure. I think it's about the question of what establishes authoritative meaning. I mean, Larry is convinced, he's explained to us his theory, the Constitution itself establishes authoritative meaning. And I think, although he didn't say, I think he's a little skeptical of the extent to which what he calls constitutionalism establishes authoritative constitutional meaning, or maybe he'll say it doesn't at all. And with regard to the right to health care, I just want to make it very clear, I'm not arguing that the Constitution itself establishes a fundamental right to health care. What I'm arguing is that the Constitution gives Congress the authority, the power, through its economic powers, to recognize rights of its own, and that the court has ceded that authority to Congress.
I'm no skeptic about constitutionalism. I think that what we sometimes call super statutes, statutes that are ingrained in our national fabric, are incredibly important. Now, they can be repealed, and occasionally a statute that seems fundamental at one time, over time, it's come to be seen as not fundamental. And sometimes things that are seen as not the business of the federal government come to be seen as the business of the federal government. That is certainly true. I do think that stories are powerful, narratives are powerful, and I think that they play a shaping role. They're psychologically powerful, right? But I actually don't think that the way we interpret the constraining force of the Constitution is about the stories we tell. It's about the meaning of the words. The meanings of these words and phrases, the regularities in usage that we sometimes call syntax and grammar, these are facts, not stories. And we can read the text if we do good historical research. And let me just be the first to say, very clearly, many people from both left and right who have done historical research on the meaning of the Constitution have done it very badly. But if you do it well, and I believe it is possible to do it well, then it seems to me that we are engaged in essentially a non-normative factual inquiry that sets constraining limits. And it turns out our Constitution then gives us great flexibility on many things, but not on others.
All right. Let me open up to questions from the audience. Since I'll just call on people if they will just raise their hand and I'll repeat the question if I to the extent I can. Yes, sir.
I've been thinking about a link between Professor Solum's constitutionalism and the written Constitution. The reluctance of many people with regard to the Bill of Rights because it might disparage, because of a statement of specific rights, might disparage other rights that they thought were important. And then the inclusion of the Ninth Amendment in the first 10 amendments might provide even a linguistic link between
So I just totally agree with the thrust of that comment. The Ninth Amendment is part of the Constitution. It says the enumeration of certain rights in this Constitution shall not be construed to deny or disparage others retained by the people. That has implications, I think, for constitutional practice, whether the implications are implications for judicial review or whether these implications are primarily directed at the political branches. That's a long and complicated question about which my dearest friends disagree in a radical way. But absolutely, I think that that's spot on the money correct.
All the way in the back.
For Professor Forbath, I'm just curious, you were assuming originalism, where exactly do you find labor rights and the prohibition of slavery and involuntary servitude in the 13th Amendment?
Well, the idea that there was a distinction between free labor, right, and slavery was the sort of animating idea of both the movements that brought forth the 13th Amendment and the particular framers of it, right? So that if we're trying to, okay, well, what did they mean? They didn't say chattel slavery, right? They said involuntary servitude, a broader concept. And what precisely did they mean by that? You with me? We have to look to, as Larry said, the sources, the context and public meaning out of which that text arose. And they had a conception of free labor, which the 13th Amendment, as it was understood at the time, was meant to usher into being. And that was itself a legal construct, right? It involved elements like the right to quit, the right to leave your employer, that the slave or any form of involuntary servitude denied. The law existed, the laws that supported various forms of involuntary servitude, and at the time peonage was among them, but so were certain kinds of harsh labor disciplines of people who were far from chattel slaves. So just for starters, and in order to keep the floor open for others, I'd say the right to quit is a labor right. It's the foundation of strikes, right? And if we, and then the right to act together, right, has come to be, right, one of the core meanings of our, right, First Amendment: freedom of association, freedom of assembly, right? And it was sort of understood in the sort of amongst those framers who had ties to working men's associations, the idea that quitting together was, right, a feature of the constitutional order was pretty commonplace. So that would be at least where I'd start the conversation.
I'll take one more question, given the limits of the human bladder. We can't continue much longer. Yeah. Yes.
Yeah, I just want to make 2 points. One, in some ways in support of a distinction implicit in what Larry talked about, which is that for this conversation, it probably is useful to distinguish between what I would call popular originalism and academic originalism. It seems to me that there's quite a large gap between those, and the existence of the gap and its political significance is a matter of, I think, some interest. The second point is much narrower. It's about these things being facts. So I'm working on some stuff about the mid-1930s. Let me tell you, here is a problem. Chief Justice Hughes and Justice Owen Roberts had an unusually long conversation at Justice Roberts' farm in Pennsylvania. If it happened in 1936, there's a good chance it had something to do with the constitutional crisis that came from 36 and 37. If it happened in 1935, it was probably about something else. The chances are it happened in 1936, but it could have happened in 1935. Now, it happened, but we don't know when it happened. We don't know in some strong epistemic sense when it happened. We know it happened. Okay. So if we can't establish that fact, I'm very skeptical kind of academic originalism that Larry is committed to.
Anyone want to respond to that? I mean, the one point I do want to say that, it seems, this point, the narrative doesn't matter for our interpretation of the facts of the text can't really be right in the way that the text is understood to constrain Congress and the government. That is, we read the text as constraining the Congress because of the story we tell about the Constitution. We passed, the Commerce Clause only goes this far because we didn't want an all-powerful government because of our history with King George. Could be one narrative that explains that text. It doesn't seem like it's possible to read the words without some story in mind for why those words exist. This is not precisely the same point as Mark's, but a response in a way. So I'm not sure whether you want to respond to Mark's point, my point, or any point.
Well, so we are going to get deep into the weeds if we start talking in a rich way about what kind of information is necessary to figure out the meaning of old words, right? But let me just suggest that one way that we do this, and it's the way that the discipline of historical linguistics does it, is by taking large databases, right, and examining not the statements of individual framers about their hopes or expectations or purposes, but we figure out how the words were used. So how was the word commerce used? Was it used, as Jack Balkin maintains, in a way that it refers to human interaction? Or was it used in a way that it refers to trade? That's a historical question, and we might be able to figure out the truth of the matter because we have a very large amount of linguistic evidence about that question. Now, I agree with you that there's a sense in which some story is relevant to the full communicative content of the Constitution. That is, words mean more than just their semantic content, right? The semantic content of words is sparse. And with the Constitution, we know more about the communication affected by the document than we get just from the words. There is a publicly available context of constitutional utterance, right? A story, if you like, a set of facts, right, about what was known at the time about the context that the framers would have known, that their audience would have known, and the audience would have known that the framers knew that they knew, right? There's a publicly available shared context. And that's important. And in that sense, of course, it's for instance, really quite relevant to understanding the Constitution that we know it was written in English. This is not a secret code, right, or a strange foreign language. And there are a lot of other things, too. We know that it was a Constitution that was adopted to replace another foundational document, the Articles of Confederation. So in that sense, yes, absolutely. Facts that constitute a shared context are important.
Go ahead, and then we need to take a break, but let this be the last comment.
I just wanted to second Mark's other point, which was the popular vision of originalism is actually, and I think we're probably going to hear more about this on the next panel in the Tea Party movement, but it's very, very, it's got a lot of political salience, the idea that we can go back and understand what the framers meant, and that should be what we do as our foundation, resonates a lot politically, and I think we're going to hear more about that, right?
Yes, we will. Great setup. I appreciate that. So we're going to take